The court simply said that it's open to you if you are so advised. The word was,
Yes.
you can go ahead and do it.
Yes.
It is not really a conferment. So that is why.
Therefore, my lord.
Yes. The supporting counsel immediately took a third point, not entertain a ban.
Well, kindly also sees order 43, rule 1W.
But the High Court, it has to be clause 15. There is no power in the revision like 227 or
No, that is not there.
or 115 that the revision would lie. Then will it be a remediless? Straight away Supreme Court.
My lord, according to me, my lord, I was checking up the law, my lord. This issue had come up, and my lord, it has been decided that if it is, my lord, from a my lord dismissal of a review, it has to, my lord, be rejected.
That is in relation to civil proceedings. You will find lot of judgments.
My lord, I'll also check in respect of 226, my lord.
In relation to a rate, what would happen?
226, I think there is a 3 judges bench judgment.
I'll check that as well, my lord.
It is suit, you are correct. But so far as the 226 proceeding, and in view of section 141 of the Code of Procedure, that provisions would not be applicable to a rate. Explanation. So it is really kept outside the purview of the civil court, civil jurisdiction. 141 explanation.
Yes, my lord, I am seeing that, my lord.
Does not include any proceeding under Article 226.
Not under order 46.
I'll check that once again, my lord. On 226, I'll check that, my lord. Without my lord looking into it, I don't want.
What you are saying, we are at work, but so far as the writ proceedings are concerned,
I think there is one decision on this, on 226.
Logic.
You know, our 5 judges bench in Ratanlal Nahata said that in 226 itself the power of review is there.
Yes, but of which
which
order? Whether it's the review is there.
Yes.
But if the review is rejected,
yes,
whether the order on review should be applicable or
parent
order is applicable.
Look, there, my lord, in an order or an application being rejected under review under 226 is a judgment within the meaning of clause 15 of the latest patent.
Do you have
and going by that,
do you have any authority on that? That this rejection will also
be last of those is
judgment will also be a judgment within clause 15 of the latest patent.
Where the last judgment is of the 3 judges bench of Madras High Court, authored by Justice Sanjeev Banerjee. Kindly have a look to this. But kindly see the first paragraph. The question is framed. The moot question that arises for consideration in this reference is whether, upon a review petition being entertained in the proceeding under Article 226 and the matter being reconsidered,
yes, not rejection.
Yes, I'll come to that. All these situations have been considered in the later paragraph. And the matter being reconsidered and the original order being retained, such an order is amenable to appeal. Now here where the order is retained. In my case, the earlier order is retained. Then, my lord, paragraph number 2 is the questions which were referred to the bench. Now, my lord, the situations are, my lord, para 9. Generally, upon a review petition being filed, there are 3 possibilities. First, the review petition may be rejected in limine, so as to say, upon the grounds urged for review being found to be unmeritorious. In the second scenario, the grounds may be found to be worthy for the matter to be reconsidered, whereupon the matter is taken up for reconsideration immediately, or such reconsideration is postponed to a future date after taking on record the new materials which is sought to be relied upon. After reconsidering the matter by taking into account new materials cited, the court may maintain the previous order. The third scenario is where upon reconsideration of the matter, the court varies or modifies or reverses the original order. Fundamentally, when the
fall within the second category.
yes,
No,
No, first category.
you fall within the first category.
yes, first category, unmeritorious. Fundamentally, when the court entertains the ground for review and decides to reconsider the matter, the finality of the original order is lost and the matter becomes sub judice once again. If the court entertains the writ petition and postpones the reconsideration for a future date, the original order does not vanish, but in effect it remains in suspended animation. If upon reconsideration the original order is maintained, the same revives, or if the original order is reversed, the same stands eclipsed and substituted by the order of reversal. It is equally possible that the original order is modified, etc. Then kindly take note what my learned friend is taking the ground at paragraph 11. Third line, according to the writ petitioner, the review petition has to be seen to have been instituted under section 114 of CPC, read with order 47 thereof, and the review petition was so instituted. The writ petitioner asserts that since the order impugned in the present case maintained the original order without interfering therewith, it is the original order which stands. Now, this was the submission while Miller defending the review application. Now, kindly take my paragraph 23. In other words, Parliament by legislation may curb the right of appeal in certain situations where orders may previously have been amenable to an appeal, but unless it paragraph 23. But in between various cases may have been quoted by the honorable bench. In other words, Parliament by legislation may curb the right of appeal in certain situations where orders may previously have been amenable to an appeal, but unless it expressly prohibits a class of appeals, appeals are founded exclusively on clause 15 of the latest patent, continue to remain maintainable. An example may be taken, I skip over the example, then the full bench decision of the Andhra Pradesh High Court and various courts have been noted, in paragraph 24. Now kindly skip over a few paragraphs. Please come to, para 40, where our Ratanlal Nahata is noted. In the 5 judges bench decision of the Calcutta High Court in Ratanlal Nahata, the court read into Article 226 itself a power of review in view of the plenary authority that such provision conferred upon a High Court. The following passage from para 58 of the report is of significance. Then para 58 is quoted. However, Article 226 of the Constitution of India having conferred a plenary power upon the High Court to exercise its jurisdiction thereunder, the power of review is implied in the said provision itself. Then please take para 48.
These from petitions.
Thus, even if it is accepted that nothing in the code applies to the proceeding under Article 226 of the Constitution, the power of review has to be traced to both the plenary jurisdiction conferred by Article 226 of the Constitution and the status of the High Court as of record, as recognized by Article 215 thereof. Then 50 is the caution. A word of caution needs to be added at this stage so that this judgment is not read to imply that when a prayer for review is altogether declined, such order would invariably not be appealable. It is possible that even an order of rejection to entertain the review may be construed as a judgment within the meaning of clause 15 and an appeal maintainable against the same. Here, order 47 rule 5 is overcome. Then kindly take para 52. But when the grounds of review are given credence and the matter is taken up for reconsideration, the resultant order will be appealable if the original order was amenable to an appeal. In other words, if an appeal lay from the original order, then the order passed upon review, whether maintaining the original order or tweaking it or reversing it, will also be appealable. This is because the nature of the assessment involved in an appeal pertains not only to the order but also to the considerations that go into making of the order impugned. When fresh materials is entertained, to reconsider the matter, the original considerations and the ground indicated in support of the original order lose all meaning and significance, and the subsequent order with the grounds in support thereof are what need to be assessed in appeal. Thus, upon a review being entertained, whether or not the original order is maintained or reversed or modified upon reconsideration of the matter, the resultant order has to be regarded as a judgment within the meaning of clause 15 of the latest patent in matters under Article 226.
Mr. Advocate General, there is no difficulty. But what I also said at the one point of time, but the difficulty that arises is that you challenge the parent order and the appellate court has affirmed the said order by dismissing the appeal. Now, if a liberty is granted to go for a review, now question is that how far the review jurisdiction can be exercised by a court. It says that review jurisdiction not only emanates from a statutory provision, but is a plenary power of the High Court so far as Article 226 are concerned, that the review can be maintained. No doubt.
Right.
The forum is also provided that this exercise of plenary power, clause 15, it's a judgment within the meaning thereof, and therefore there is no difficulty in maintaining appeal.
Right.
So we are not. He was taking a third point. We were not really very happy with that. Anyhow, the judgment also corroborates that there is no difficulty in maintaining an appeal.
Right.
And Order 47, Rule 7 would not stand as a bar in maintaining an appeal because it is not an appeal under the Code of Civil Procedure, but it is an appeal under the latest patent.
Yes.
So this is how we have to perceive, no difficulty. Only thing is that how, if the appellate court did not interfere with the original order, and the reason has been given that why he does not want to enter into this. Once it is done, then it will tantamount to merger of that particular trial court's order into appellate court's order. Whether a review before the single bench is maintainable
Yes.
when the order is affirmed by the division bench.
Well, first is
That order. That is what I am asking. That once it is affirmed, it merges. Then how can you
Whether the single bench can modify that order?
even modify or entertain anything to be touched upon? Or I am going into the very basic one, whether the review itself is maintainable.
well, according to your lordship's prima facie view, since there was a merger, therefore there is no question of any review by the court below or the learned single judge. But please look into the order of the learned appellate court.
As seen,
Yes.
the liberty is granted to agitate the point in the review jurisdiction.
Yes. Now,
I am saying
Yes.
that this was unwarranted. The court, the moment the court dismisses the appeal, then and there it becomes a functus officium. He lost the sin of the matter. There was no occasion to pass a further direction conferring a particular right which is otherwise not amenable or available under the law. In a normal circumstances, if the parent order is affirmed by a appellate court, can a review be maintainable? No. Answer, I think you will also say no.
if
SLP is not an appeal in
No.
that sense. It is
SLP is not an appeal.
a thief to appeal. So it's not a question of merger if it is dismissed in limine. Kamayatun Asam.
Kunaya Ahmed.
I can't pronounce that.
Kanaya Ahmed, madam.
Kamayatun or something.
Kunaya
Kunaya
Ahmed.
Ahmed.
SCC, I believe.
2006 SCC, I believe.
2000,
2000, volume 6.
volume 6.
আরেকটা আছে না celebrate
Mr. Muzumdar is very good in remembering numbers.
No, no,
Apart from the other good
also not bad.
qualities that he has.
I am also not bad. Numerical numbers are. This is what the situation.
Yes.
Can the court grant that liberty?
section 5
Milord, today, Milord, please consider, Milord, possibly subject to correction, Milord. This bench possibly cannot go into that. Otherwise, that would amount to revisiting the previous appeal court's order.
Tell you why I said that judgment to be cited.
Yes.
Praveen Pandey.
Praveen Pandey.
In that judgment, what has happened? There was a suit filed by a
judgment
subtenant claiming a right of tenancy.
Appeal. Appeal.
And there was a suit filed by the landlord against the tenants for eviction on the ground of subtenancy. Sorry, the suit was filed by the tenant for declaration and suit filed by the
Subtenant for declaration of tenancy rights.
tenant for declaration that he has a right to sublet.
Acha.
And the suit was filed by the landlord for eviction on the ground of subletting. The first suit was taken up. Those were in different courts. It was decided tenancy right, subtenancy right to sublet was not held. Then at the appellate stage, an application under Order 41/27 was given that in 1956 Act, there is a provision that a statutory notice, if it is given, then you cannot seek a eviction on the ground of subletting. He is a notified subtenant. This document and the reply by a landlord was also sought to be relied upon before the appellate court. The appellate court says, I am not entertaining now all these points. Order 41/27, I am not. I am dismissing it, dismissing the appeal, but giving you a liberty
To go back.
to rely all those documents in that suit. That will be a vital one because
The other suit.
in that eviction suit, where if a notice is given of a subtenancy, then unless the subtenant is also made a party, the suit cannot be maintained in 1956 Act. That was the spirit of the division bench. And then gave a liberty that all these documents you will rely upon and the court will decide that. They went and relied upon those documents. The court says, I will not look into this since the appellate court rejected, did not accept this Order 41/27 and cited against you. So we can't. Liberty was shown that this was given and you will have to. Nothing, dismiss, appeal, appellate court held that this liberty was surpluses. Should not have been. When once you dismiss appeal and Order 41/27, there was no occasion to give a liberty to rely upon those documents and to consider it. The matter went to the apex court. Apex court entertained the appeal, admitted the special petition. What would be the effect of this? And ultimately, by an elaborate judgment, says that those were surpluses. Once you dismiss the appeal, you become functus officio.
Right.
You can't pass any order which would really reopen or revisit, which invite a revisitation. That you cannot do. That's why I asked that particular judgment to be placed.
But I'll try to find out.
Here is a case which is distinguished on facts. It was your submission that I will go and agitate that point.
Right.
The court simply said that it's open to you if you are so advised. The word was,
Yes.
you can go ahead and do it.
Yes.
It is not really a conformance. So that is why
Therefore, my lord, yes.
the supporting counsel immediately took a third point, not entertain a paragraph.
Therefore, my lord, first, my lord, I need to satisfy your lordships that whether at all a review is maintainable after.
Absolutely. That is what is the
Then we are on the merits of your.
Absolutely.
I'll come with that.
review is maintainable. We are not saying appeal.
Yeah, I get your lordship.
Review itself is maintainable.
Very good.
And Mr. Mujumdar's immediate junior, I don't think so. We are very satisfied with his.
No, of course, he will take all technical objections that he can.
When the state takes all technical objections to deny incentive, we have to take all the technical objections to. When state takes all technical objections to deny incentive, then we have to take all the technical objections.
No, there is no technical point at all. The first line itself is sufficient to throw away his writ petition. He is asking refund of tax. There is no law in our country for refund of tax. Supreme Court said that there is no promissory estoppel. There can be no enforcement of an order of refund of tax from 92.
That's true. That's on the merit.
Yes, that's on the merit. So no technicality involved.
Can you reopen that merit is a
Yes,
Second
definitely,
issue, first
definitely.
thing is maintainability
Yes, yes.
of the review.
I'll come back.
Interpretability of the review, then we'll consider the
Right.
point.
And man, this is an appeal arising out of a dismissal.
Order 47, Rule 7 will not come into play. Will not.
Will not.
141 says that the provision of the code relating to a suit will not be applicable in a proceeding under Article 226. Explanation is given. So that is excluded
Lordship is referring to
from the purview of proceedings
proceedings.
because this is emanating from 226, where the
Right,
plenary powers to entertain the review is in
Lordship is referring to section 144.
141.
141.
141 of the code.
Code.
Please
See,
read
please.
explanation.
141.
Explanation.
Read. It will not apply to read. Will not.
This will be a
But
judgment.
the principles will apply, my lord.
The
But the
word
principles will apply.
No, the word proceeding which is appearing in the Code of Civil Procedure shall not include a proceeding under Article 226.
But in one judgment, which my junior,
These are all from civil suits.
no, one judgment which went to Supreme Court, that was an order dismissing review petition in a 226 matter. And then the Supreme Court held that no appeal would lie under Order 47 Rule 7.
I think that is a matter pertaining to a Kolkata Corporation matter.
I
arising
have
out
the
of.
judgment. No, I don't think so, my lord. Subject to correction. কোনটা এই যে সুশীল ফাইন্যান্স এটাই
কোন কোর্টে গেছে
এটা গেছে হচ্ছে
Judges bench.
yes I'm just checking my lord এটা কোথায়
নিচে নিউ দিল্লি কনজিউমার ডিসপিউটস
না একটা আছে 226 আরেকটা জাজমেন্ট আছে দাও 226 এ that's a justice Pasay's judgment, justice Pasay's judgment, correct.
এটা 226 মানে হাইকোর্টের ডিভিশন বেঞ্চ 226 থেকে আছে
Well, if a lordship kindly have a look at this judgment. Oh, this is a marked copy. Kindly. These are arising out of 226 only.
প্যাটিশনটা বল একটু
But this was troubling me also, that whether this exclusionary clause would apply or not. This is 2007-15 SCC. यही ना ट्वीट से हुआ था ना
715 एससीसी पेजটা বল
page 370.
You have given me one more copy. তোমাকে উল্টো দিয়েছে নাকি শিবকুমার?
I'm sorry, my lord.
15.
হ্যাঁ ঠিক আছে।
ওটা ওনাকে দিন
কিশোর দাই দিও
It relied upon 1994 volume 2.
yes
You have that
I
judgment.
have that, I think. 1994 volume 2 টা দেখো Shankar Motiram Nale. But in fact, that judgment has been relied on by the Supreme Court in
675 and 677. But this is the three judgments which is relied upon, but does not lay down in explicit terms that whether the appeal lies or not.
I
Whether
think
this judgment, Mr. Advocate General,
yes ma'am
whether this Shivcharan Singh has been considered here.
and
In
the
that,
other
special bench judgment of the Madras High Court.
the other decisions which were relied upon in that.
আচ্ছা
বেঞ্চ দেখাচ্ছে
Mr. Mujumdar, I think there is an old judgment of
No, it
our
is
High
not.
Court.
It is not. No, Shivdev Singh has been considered.
Shivdev Singh is that 1960s judgment.
but that
That
I can
is
file a separate writ for it.
separate read.
When the powers are so wide that we can go for a separate writ also.
So Mujumdar, there is an old judgment decision of our High Court.
Our High Court. Well, we will try to
on
find out.
writ petition.
We'll try to find out. Because I was looking for writ petitions.
Yes.
Review arising out of writ petitions.
Yes, I think on writ petition.
I will try to find out, my lord, definitely.
Justice Bhattacharya, Bhaskar Bhattacharya's division bench have done away with all
And
nomenclature.
that is Maruti Real Estate.
all
But
nomenclature.
I told my junior that
The
Learned
modification
Advocate General would
is
rely on Maruti Real Estate.
There will be no period of limitation.
I know. I know, my lord.
Because I appeared in that.
I know. In one matter, your lordship pointed it out.